Johan Saw here again, Constitutional Coop Headquarters. Boy, is this a great time to be where I am. And I hope you can tell, with the passion I have for what I do and in concert with recent events, even at my advanced age, and I'm in my 74th year, life is ahead of me. And that's what I want to teach you so that you'll know it's ahead of you too, especially based on the recent OSHA decision by the U.S. Supreme Court. And this is something I've been saying now since late 2020 with the appointment of Barrett uh, and the change of direction that the Supreme Court was showing in some earlier cases that I had mentioned, Texas v. California being a big one, where the court refused to file documents from the state of Texas, yet at one and the same time, Article 3, Section 2 U.S. Constitution says that in all cases in which the state shall be a party, ALL, the Supreme Court has original jurisdiction. The state of Texas had nowhere else to go, and they did it in the election case, quote unquote, election that involved Texas and a lot of other states too. And there's only one or two things that could have happened there. One, the Supreme Court has taken, summary control of its original jurisdiction, and apparently they can amend it by the U.S. Supreme Court rules, Rule 1 in particular, which I'll be talking about in another video, where all doesn't mean all. Wait a minute here. I thought the amendment power came under Article 5, not Article 3. So that does seem unlikely. What did happen, and you'll learn all of this when you get my materials and learn, send me an email, youwinnincourt@gmail.com. The ratification, quote unquote, with a capital RAT of the non-existent 14th War Amendment did away with all of the sovereign independent states north and south of the Mason-Dixon line. Therefore, you look at Article 3, Section 2, and it says, in all cases in which the state shall be a party, if there are no states, ain't no problem. And that's one of the biggest indications that that's true. And that helps us in so many ways. It's hard to even, in a short video like this, get it across to you, what it means. But think about it, no states. And if we're territories or whatever it is we are, and I think it best for federal insular territories, Congress is without power to provide for elections, especially for president. Electoral college, anyone? Voting members of Congress, and the Senate is still an appointed position, by the state legislatures if we had states. Astounding when you think about this. But that's the way it is, black and white. The framers, of the Constitution did make some mistakes in it, no question about that. It wasn't a perfect government, only the best one ever invented, and we need to get back to it. A federated Republican form of government of defined and limited powers, rather than the democracy we have now. 3 wolves, 2 sheep voting on what's for dinner. We get back to where we were, we can make changes from there and do it the right way. Whatever changes we want. And to be sure, if that happens, and this is what it is, the sovereign body politic of the nation and republic, free, white, male, 21, no apologies. Can't be changed unless done consistent with the Constitution. And the 14th War Amendment that purports to do that, as you'll learn from getting my materials, send me an email, youwinnincourt@gmail.com, violated all 6 articles of the Constitution. Right or wrong, good or bad, it doesn't exist. And lo and behold, wouldn't you know, the Supreme Court actually ruled it contemporaneously unconstitutional, at least the Reconstruction Act, and the 14th Amendment is intimately connected to that. If that doesn't exist, neither does the 14th Amendment, and neither do. But they were not allowed to announce their opinion to the public. A case called Ex parte McArdle, 7 Wall 506. And they got the message back then too. Don't go there again. Because we have another area that we want to get into, raising issues of bills of attainder. And wouldn't you know, in that time frame, the Supreme Court made its last serious ruling on bills of attainder in Cummings v. Missouri. I think 677. I might be off on the site, but 150 odd years, and that's not accidental because every law on the books, lo and behold, it's either a bill of pains and penalties or a bill of attainder, the taking of life, liberty, or property without judicial process. And you start raising these arguments against mortgage banksters for openers who have fraudulently induced you into an agreement that doesn't exist. And indeed, the bankster himself doesn't exist. You're absolutely going to love it. And we can prove it. Or you get into family law court, which may be the worst of all, given the stakes that are there. They don't exist. And by the way, with no states, guess what? All these black robe bastards, not to mention state bar association attorneys, they're in official positions in government. They have to be appointed by the president pursuant to Article 2, Section 2, the Appointments Clause. Now you start asking for those certified copy of those documents, which they can't produce and do it from day one, ideally. Guess what happens? That's what gets you out of trouble because you're saying structural jurisdictional errors, and especially these black robe bastards are not in any official position of honor, profit, and trust in government. And what we do is set an unopposed record against them in their own friggin' trial courts, quote unquote. And we then go after them with a petition for redress of grievance, not civil rights, Inc. And if they didn't have jurisdiction, there isn't even any qualified, quote unquote, judicial immunity, let alone absolute immunity. They're liable. That's one of the ways we get our nation and republic back, is to make those points. And if need be, and this is an area I'm working in now, because the Supreme Court has said, in a case called Coleman v. Virginia, the best decision they ever made. In effect, not a direct quote, but they said the court must exercise jurisdiction if it has it, and at the same time, it must not exercise jurisdiction it does not have. The one or the other is treason to the Constitution. And I would personally like to put as many of these bastards away as I can and send Clinton out there next to the cell block. I think it's 2455. Death row, because that's where you go when you commit acts of treason, especially if you're sworn by oath to obey this Constitution and laws enacted in pursuance thereof. These are the areas we need to start attacking. The hell with civil rights, the hell with due process, equal protection, doesn't matter. We have a right to trial by jury according to the courts of the common law, as even secured the inhabitants of territories, for crying out loud, by the Northwest Ordinance of 1787, as reenacted by the first Congress. But if any of you have a trial by jury like that in your jurisdiction, wherever you are, I'd love to hear it. We don't have anything remotely resembling that in California, but we should. It's a huge issue. The hell with all the other ones. This is the biggest and best issues we're going to get are the ones I advocate. You can learn how to do it. Send me an email, youwinnincourt@gmail.com, and I'll get back to you. It's a lot of goodies. You're going to love it. And you can learn yourself, teach your kids, and they'll teach their kids and our posterity, and they can get out from under before the system ever has a chance, to sneak in there and take them away from you, which they think they can do. In fact, one of the latest things I'm hearing, but not officially, is that Congress might consider, taking unvaccinated people and putting them in concentration camps while summarily removing their children from their custody as unfit parents. Boy, I talk about the black is white mantra that goes around so much in CIA language. That's exactly what it is, because we're some of the most competent people out there and want to protect our children and keep them safe, from this federal, regional, martial law government. So like I say, you'll learn a lot about this. Send me an email, youwinnincourt@gmail.com. And it doesn't matter where you are, family law, mortgage, banksters, traffic court, tax court, doesn't matter, because these agencies don't exist, and or we certainly haven't agreed to let them have any jurisdiction over us. And we can prove it. How great is that? I mean, if you'd have seen my South Carolina case that hauled me across the country for 2 months on 4 federal unmarked military aircraft, could have got there on 10 hours on United Airlines. And I finally get there, and the first appearance I had, I shut them down in 30 seconds flat. It's $1 million video if I had it. If they read the charge, practicing law without a license, and that's a felony there. And I'm standing there, manacled hand and foot, and in a red jail suit. I laughed. I said, the problem with that is I don't practice it. I get it right the first time. And then the judge, who I think was one of the good ones, ultimately said, well, we have to check and be sure you're competent to represent yourself. And if I could have thrown my hands up, I would have. And I said, oh, Barthetta, Beretta v. California, Judge 422 U.S. 806. The problem with that is the Supreme Court ruled in Barron v. Baltimore 7 Peters 243, 1828, the Bill of Rights doesn't apply to the states. Stunned the courtroom into silence. Everybody had never seen anything like that before, and they all knew they were the ones in trouble with the law, not me and not you. And you don't have to be that good to get that far. Happily, I am, but you don't have to be. I'm going to teach you all you need to know to get a similar result like that, because they can't have these issues come up officially on the record. That's why they've never even acknowledged any of my documents, whether it's a bill of particulars, motion to dismiss, brief on the 14th Amendment, things like that, brief on new states. They can't do it, because if they do, that admits treason on the record, and they're already in enough trouble. Yet if they don't do that, we have no way to put a defense on. I mean, think about that. Bill of particulars, nature and cause of the accusation, that's jurisdiction and venue of the trial court, and rules of the con game. Elements of the crimes which they can't identify, because these days they're all federal commercial offenses, and that's 27 CFR 72-11. And that jurisdiction is nothing but admiralty and maritime, which all state courts are barred from exercising. And there's never an injured party. So therefore, there's no way that you're going to have the right, to invoke your unopposed right to confrontation and cross-examination. Can't possibly be in a criminal jurisdiction if that's the case. And even in a civil jurisdiction, that's not where you are if you're going to learn from getting my materials. Send me an email, youwinincourt@gmail.com, and I'll get right back to you with a lot of juicy information and offer of my materials that you can get very modestly priced. Looks like to me about 1/10 of 1% of what you would pay for a 4-year education in a law school if they were teaching these things these days. And they sure as hell not at Starboard, Yale, UC, Berkeley, ain't none of them. No need for it anymore. In fact, Berkeley, thank you, Irwin Chemerinsky, the dean of the law school over there, the last term before last, apparently removed the only course they had on constitutional law and relegated it to an elective. It makes sense. Why the hell would you want to spend time and money on learning something that's not taught anymore and it doesn't matter anymore? And they think it doesn't exist. That's how bad it's gotten. But we can take advantage, and with this recent OSHA decision, and like I said, I've been saying this for over a year. I know where the Supreme Court's going. I'm really good at reading between the lines, which you would expect after entering my 4th decade next month, 15 years all in. I know what the hell I'm doing. And I can teach you so that you'll know, even if you don't get near as good as I do, at least for a while. You don't have to. If you go in there with my documents, and especially at the moment with almost 600 jury instructions, and by Easter I may have 700, and you get my materials, you get a full update on that complimentary when it happens, for 1 year. So you get all those extra jury instructions. It's going to take a little while to do that, but they will be there. But that's what they can't stop. And that's how good it is when you learn your rights and know the truth. Would have been real nice if they told me that back in the day when I was in high school 50 odd years ago, especially right outside of Washington, D.C. Didn't happen then, not happening now. So that said, I don't want to go on too long here, but it's really exciting news for all of us, what's happening on the U.S. Supreme Court. First time in arguably 9 decades, they've acted like an Article 3 judicial court, and they're the only one ordained and established by the Constitution. And again, reading between the lines, I think what's going on now is that the lower court judges are going to get the message here, overtly or otherwise, from the Supreme Court. We're starting to do our job. you damn well better start to do yours. Best news we've had in the entire time I've been at this. That said, remember to subscribe, like the videos, tell your friends, get the word out. The sooner we finish, get rid of all this divide and conquer BS they've been doing for at least 150 years and work together, Asians, Americans, and Africans, the quicker we get these bastards off our backs. Thank you.